Hello Lawyer, I'm Catherine Mason, the Director of Cambridge Law Studio. I must confess I was one of the founders of the TOLS exams. That's my fault. Welcome to our quick legal vocabulary class. Boilerplate clause. A boilerplate clause is how English-speaking lawyers describe the clauses that come at the end of a written contract. A clause is a numbered paragraph in a written contract. Some law firms call these paragraphs articles. So a clause in a contract is a numbered paragraph. We say clause 1, clause 2, clause 3, etc. Now I'm very English, so I always say clause, but internationally you might hear lawyers saying Article 1, Article 2. It means the same thing. It means paragraph. And at the very end of a written contract, you'll find what we call the boilerplate clauses. So, there are two types of clauses in a contract. In English law, we name these as the operative clauses and the boilerplate clauses. The operative clauses are considered more important and are negotiated for weeks or maybe months. The boilerplate clauses come afterwards. So, operative clauses, just an example. If you and I were negotiating a contract where my client in England was buying something from your client in your country, the operative clauses are the things that we would talk about for a long time. For example, the condition of the thing we're buying, the price of the thing we're buying, when it will be delivered, who will pay for transport, who will pay for insurance on the journey in case of damage, what happens if it arrives and it's faulty, there's some problem. Those are operative clauses. The boilerplate clauses are kind of secondary, they're not quite so important, and they're usually copied and pasted without negotiation into the contract. An example of a boilerplate clause is the entire agreement clause. It is normal for English lawyers to include this in all written contracts. Another example of a boilerplate clause is the severability clause. This is also normal in all contracts drafted in English. Entire agreement clause. That comes at the end of a contract after all the very important things, and it says, this written contract constitutes everything about the agreement between these two people. Nothing in an email previously is included, nothing in a WhatsApp message, nothing said in a conversation. All of that is excluded. Everything we have agreed is in this agreement, this written and signed agreement. That is the entire agreement clause. Severability clause. It's another boilerplate. It comes at the end. The verb to sever means to cut, and it means to cut violently, like the guillotine, off with the head, cut. And it means if anything in the written contract turns out to not be valid, let's say you're in Italy and there's something in this English contract that is just not legal in Italy, the severability clause is there to save the contract. It says that illegal or void part of the contract will be cut dramatically out, and the rest of the contract will continue in full force and effect. So that's a boilerplate clause that is there to save the contract by cutting out anything that might not be valid in one of the two jurisdictions. Now, in English contracts, we have to include a force majeure clause as a boilerplate clause. Because we have no civil code, there is no presumption of a force majeure in English law. Now, that is probably very strange to you because in your legal system, force majeure, I said force majeure, didn't I? I tried to say it correctly. We say force majeure. It's not automatic in the common law. So if one of the parties wants to use the force majeure clause and say, oh, there was a flood, there was a volcano, that's why I didn't deliver the goods, be careful, because English law does not give you that automatic right. You have to include a force majeure boilerplate clause, and if there isn't one in the contract, you're going to have a problem in an English court. So there you are, 3 boilerplate clauses: entire agreement, severability, force majeure. In the UK, lawyers usually describe this type of clause as boilerplate. However, some international contracts which are drafted in English refer to them as general or miscellaneous clauses. So a boilerplate clause is the same thing as a general or a miscellaneous clause. That's a difficult word. Boilerplate is easier. So if you see general clauses, miscellaneous clauses, in England we would always say boilerplate, and they're all the same thing. Congratulations! You can now use the words boilerplate clause like a legal professional. And if you haven't done it already, your homework from me in Cambridge is to go follow the link in the description, download your free PDF and study some words. See you next time. Bye for now.